Hi everybody, hi students. This is a lesson, the very first lesson on contract law. Before the start of the lesson, I introduce myself. I'm Ram Segan. I'm an in-house legal counsel. I hold a law degree from a university in England and also a postgraduate law degree from a university in England. Now, the lesson objective of this particular contract law, this particular lesson, is at the end of this lesson, students should be able to understand the 4 basic rules of the formation of an agreement. The key terminology: identify when a contract has been formed, able to identify whether the issue with the contract's formation is with the offer, acceptance, certainty, intention, or consideration. Now, the contract, to be valid, it must have certain attributes. These are the attributes: offer, acceptance of the offer, communication, consideration, intention to create a legal relation, and the capacity to enter into a contract. Learning outcomes: the definition of contractual offer, the distinction between a unilateral and bilateral offer, difference between an offer and other communications, the moment effective communication of an offer, and what is not a valid acceptance, the requirement of communication or acceptance. Alright, the contract law. The difference between subjective intent and objective intent. So what is subjective, what is objective? Then we're going to learn today this particular lesson on subjective intent and objective intent. But what is important is what the court disregards a party's subjective intent. So the court only take the form of the objective intent. So the court disregards a party's subjective intent, which is his or her actual state of mind, and focuses more on objective intent, which is the intention of a rational person under the same circumstances. Alright? So what is this difference between subjective and objective intent under contract law? Now, to determine whether parties to a contract have the intention to start a legal relationship, the court uses a test of contractual intent. Such a test is objective and not subjective in nature. It uses an objective approach to validate a contract's enforceability. The court disregards a party's subjective intent, which is his or her actual state of mind, and focuses more on objective intent, which is the intention of a rational person under the same circumstances. It does not interfere in a person's personal mental sphere, but looks at the situation from a reasonable person's point of view. It is not necessary to have a subjective meeting of the minds to make a contract legally enforceable. The court evaluates the entire situation and attempts to find out whether it will be rational to ascribe to such an intention to the parties. In the event that requirements of the contractual test of intent are not met, the court will assume the party under consideration did not have the intention to enter into a legally enforceable contract. A disparity may exist between the party's objective intent and her subjective intent. Now we go one into steps into subjective approach and later into the objective approach. Now, what is the implication of a subjective approach? Now, some legal experts believe that the subjective approach to contract law should be given more importance. This is just an opinion and also some academic papers on the differences between subjective approach and objective approach, and how legal academics, law academics view from the point of view of these two topics in subjective and objective approach. This these particular slides may help students who are doing postgraduate studies and trying to give or giving opinion on the differences between subjective and objective approach. For example, trying to analyze critically the differences between a subjective and objective approach, and writing an essay, critical analysis, on a subjective and objective approach. This may help a little. Now, some legal experts believe the subjective approach to contract law should be given more importance. This is because limiting the creation of contracts to objective intent alone may unduly restrict the formation of contracts. This approach, however, has its positive and negative implication. If subjectivity of intent plays a more significant role in determining the enforceability of a contract, it will broaden the scope of contracts being created and not limit them to being formed based on objective intents alone. As such, it can facilitate the creation of genuine contracts. Because if you have in mind, A, you want to buy oats, and the other person, the other side, who's selling you the oats, knowingly that you wanted oats, but in the form, the contract, you objectively put in paper, in writing, and through the exhibits of the character that you are taking in new oats. Therefore, here the opinion says it can facilitate the creation of a genuine contract. Nonetheless, the problem with the subjective approach to contract law is that it may require the court to consider and give unnecessary importance to data that may not be accurate or reliable. This can undermine the court's ability to deliver justice. Then again, if a party's subjective intent is backed by a valid and trustworthy evidence, it can enhance the justice delivered. Now, still we're going to this topic, going forward and going along with this topic. To determine whether parties to a contract have the intention to start a legal relationship, the court uses a test of contractual intent. Such test is objective and not subjective in nature. It is not necessary to have a subjective meeting of the minds to make a contract legally enforceable. This is an example of a real case of Smith versus Hughes. Now, in English law, basically, it's based on precedents, other than the coded laws. So this particular case is the precedence between Smith versus Hughes, or Smith against Hughes. It was held that there was a contract between Mr. Smith and Mr. Hughes, and that it would not be avoided. The objective test revealed that a reasonable person would expect the sale of good quality oats in a similar contract, since there was no express discussion of old oats. Another case we can look at is the RTS Flexible System Limited versus Morcaril Alloys Mugler. Okay, valid contract concluded despite subject to contract clause. Okay. Now the facts of this whole case is that the claimant, now in England, you call claimant, right, was a supplier, you call claimant, was a supplier of automatic machines and agreed to manufacture an automated system. In the defendant's factory. Work began on the basis of a letter of intent with a long-form contract to follow. The letter of intent expired. Whilst negotiation on a long-form contract continued, a dispute arose as to whether the defendant's performance requirement was satisfied by the machines delivered by the claimants. So the issue here is that the claimant sued for the balance of the purchase price on the basis that either a continuing contract or a new contract formed upon expiry of the letter of intent, or that it was entitled to be paid a reasonable sum on a quantum numeric basis. The defendant counterclaimed for damages on the basis that the parties had concluded a simple contract which has no limitation on liability. The High Court held that after the letter of intent expired, a new contract was concluded which applied retrospectively. The Court of Appeal held that there had been no contract. So there are two. One is the High Court saying that there was a contract concluded, but later they went to appeal court and there was no contract. So the final one was this: there is no contract. The defendant successfully appealed to the Supreme Court. The court considered the communication between the parties in terms of words, and conduct, and whether it could be objectively concluded that honest, sensible businessmen in the position of the parties intended to enter a legally binding relationship. In the circumstances, the idea that there was no contract was unconvincing. Where a contract is negotiated subject to contract and work begins before the final contract is executed, it depends on the circumstances whether parties waive the subject to contract terms. In instance, the unequivocal conduct of the parties led to the conclusion that there had been a binding agreement to waive the subject to contract provisions. Now, so generally, You will see this in all construction contracts and contracts due to construction, where you say, I give you a letter intent, but this letter intent on condition that certain terms to be fulfilled later. So once those terms are be fulfilled, then the subject to contract shall be a contract should be executed. So it says here, in the instance case, the unequivocal conduct of the parties led to conclusion they have made a binding agreement to waive the subject to contract provision. So there's a subject contract. So both parties show that they have waived this, subject to contract provisions, meaning that it is objective intent. They objectively intended that this should be waived, not in their mind, but objectively they show reasons out that they are going to waive this subject to contract provisions. Therefore, there is no contract. That's what the Supreme Court says. Whether there is a binding contract between the parties, and if so, upon what terms, it depends not upon their subjective state of mind, but upon a consideration of what was communicated between them by words or conduct, and whether that leads subjectively to a conclusion that they had agreed upon all the terms which they are regarded as essential. The second case here is about controversial estates versus departure from the objective theory of the agreement. Harthoff versus Collins and Shields. Now it should be noted, however, that there is one circumstance when the courts will depart from the usual objective approach and take account of the actual subjective knowledge of the offeree. Under this approach, sometimes known as the snapping up doctrine, an offeree is not allowed to accept an offer which he knows is mistaken as to its term. Now this last factor is important and is what limits the scope of this application of the usual objective approach. It is not enough to come within this exception, that the offeree was aware that the offerer had made a mistake. The exception will only apply where the offeree is aware that the offerer is mistaken as to the terms he intended to do or to offer. The similar cases, the mistaken as to its terms. Stoll versus Louis Defoe's Energy Services and Scrivium Brothers versus Hinley. Now, the next topic we're going into is offers and invitation to treat. Now, what is an offer? An offer is an expression of willingness to contract on certain terms. It must be made with the intention that it will become binding upon acceptance. There must be no further negotiation or discussion required. This example is shown in the case of Storer versus Manchester City Council. The Court of Appeal found that there was a binding contract. The council had sent Storer a communication that they intended would be binding upon his acceptance. All Storer had to do to bind himself to the later sales was to sign the document and return it. The next case is on the other side. Now this case is that you have to sign and return it. The other case is Gibson versus Manchester City Council. The council sent Gibson a document which asked him to make a formal invitation to buy. Now this is an invitation to buy, and stated that the council may be prepared to sell the house to him. Gibson signed the document and returned it. The House of Lords held that a contract had not been concluded because the council had not made an offer capable of being accepted. It is just an invitation. So the words "may be prepared to sell" are fatal. So is the invitation. Not, be it noted, to accept the offer, but to make formal application to buy on the enclosed application form. It is a letter setting out the financial terms on which it may be the council will be prepared to consider a sale and purchase in due course. So you have to make a distinction, students, class, you have to make a distinction between a invitation to treat and an actual selling. If I sell you something, I'll say, okay, yeah, this thing is to be sold at this price, and you take it, you pay it, you take it. But if I say, please offer me, right, a price, and I will take it. So it is not a acceptance. You know, I'm just inviting you to give me an offer. So this is the invitation. So the next a statement of intention is Harris versus Nicholson. So what is the next one? A supply of information. Now, if you just gather information, you're asking for more information, is that actually constitute a formation of a contract? Let's see the case of Harvey versus Facey. Now, one party provides information to another party. He supplies the information to enlighten the other party. The statement is not intended to be acted upon. Where one party telegraphed in response to the query of the other what the lowest price was that he would accept for his property if he were to sell it. This alone did not imply an assurance that he would sell at this price. So next we will go to an invitation to treat. Before that, so this is the other way around. So if somebody tell you, somebody were to tell you, say, I would offer you offer me the price, you give me the price, and I will think and consider whether I will sell you. So you give you a price, then it says, this is not an acceptance, this is just an invitation. You invite me, you know, to buy, to give you a price. Then I give you a price, then you buy from me. So the next one is an invitation to treat. Clearly, this is clearly an invitation to treat. So there are 2 parts here, 3 parts here, 4 parts here. So the first part of invitation to treat is a display of goods. Display of goods from the shop window, outside the shop window. You can see from outside the shop window is generally an invitation to treat. Next, an advertisement. An advertisement is an invitation to treat, where bilateral contract is anticipated. So a very good example is Carlisle versus Catholic football. The next is request for tenders, request for prices, request for offer. Now we are going to a summary of the first chapter. A contract begins with an offer. The offer is an expression of willingness to contract on certain terms. It allows the other party to accept the offer and provides the basis of the agreement. An offer exists whenever the objective inference from the offerer's words or conduct is that she intends to commit herself legally to the terms she proposes. This commitment occurs without the necessity for further negotiations. The first step in finding a contract is to establish that there is an offer and who is making it. Now, we studied earlier regarding the objective and subjective inference, right? So it is important that the objective part of it is taken into consideration. You should not and you just don't bother about the subjective form. Now, in continuation with this, many communication will lack this necessary intention and thus will not be offers. They may be statements of intention, supplies of information, or invitation to treat. Although the distinction between the offer and the steps in the negotiation process is easy to state in theory, in practice, difficult cases arise.